Good morning. My name's Todd Vivrette, and this is It's Your Estate. This is week 3. We're going to talk about wills and trusts, and that's where we stand. So at this point, we are incidentally in. There is also, I'll come back to where we are. This is the workbook that's available through the website, and we will show you that in just a moment. Let you go through and follow along with what all's going on with the material over all 6 weeks. Where we are in terms of the schedule, we are in week 3, and we're going to be talking about wills and trusts today. Then we do retirement planning, charity, and estate planning as we go through those. I had mentioned that we were going to show you where these are. So
by the way, if somebody wants to use our website, it's IYME. You could just use IYME. You don't have to use that preliminary IYE. So or you could spell it out. It's Your Money and Estate.
And in the email that you got inviting you to be here, it also shows, you just click on that link. When you come in, there's a button called workshops. For instance, in our case, we would go down here to It's Your Estate. And in that, you can see all of the weeks, the videos from prior weeks that we have. And at this point, we're on wills and the trust, wills and trust. Come here, click. Okay, that doesn't want to work. Think.
There it is.
Okay. And then under Zoom, here's what Steve's outline is going to be, or his material. Ask First Forum, and the workbook is also there. And Pete likes to talk about his articles. Yeah,
just we put a variety of articles that are pertinent to today's topic. They're there for you to take a look at. You know, so a lot of individuals have questions on the probate process. It's there. You could have a variety of different trusts that, and we talk about those, and they're just supplemental material if to the presentation today. Can we go to our speakers? Should we? Can Steve be?
Absolutely. Steve should come in now, and I'm going to disappear and I don't know, maybe take a nap since I don't see him working very well here. I'm going to monitor Q&A. Steve's trying to figure out what the heck we're doing here.
And he didn't.
It's not like this is our first week of doing this or our first year of doing it. I'm going to monitor Q&A, so I will be responding to those as we go along. And bye.
And Steve didn't fall asleep. Thank
you,
Steve. Pull up your Ask First form, please.
Sure.
By the way, financial and estate literacy, we're a not-for-profit as well. Our mission is to educate you on estate planning, financial planning, and charitable planning, and hopefully provide a safe zone for you to learn this stuff. We use the Ask First form because it's your control if you want to do business with Steve. Steve does not get your contact information, and you will not hear from him. Master's degree or other advanced degree, I'm assuming that's your Juris Doctorate?
Yeah, Juris Doctor degree, achieved that in 2014.
And you've been practicing in the estate planning area for the past 8 years?
Yeah, since 2014. So I think
okay.
It's a little over 8, but
and you're exclusively in the estate planning area, pretty much. The law firm has expanded, and I should turn off my phone. Talk a little bit about your practice.
Sure. Yeah, so we do trust and estate administration, litigation, and estate planning. And we also have a family law side that handles child custody issues as well as divorce matters.
Okay.
So I predominantly am on the estate planning, trust and estate, and litigation side.
Okay. You're licensed in Washington and in California. So, and the reason for that is?
I'm actually planning on getting licensed in a couple of additional states. Just one of the main issues is we get a lot of people that have been moving out of California, but it's also helpful for a lot of businesses as well in a couple of other states I'm looking to get licensed in.
So
expect that to be the end of this year.
In addition, is that you cannot practice in another state without being licensed in that state, and the laws are different in each state.
Yes.
Yeah. Property, there's no national estate planning law.
Yeah, no, they have they have like uniform codes, but each state alters it ever so slightly, just to make life a little bit more difficult.
Yeah. Okay. Tell us how you charge your clients.
Yeah, so we have a variety of different fee structures. So certain things are flat fee, some issues are percentage based, others are hourly, and some are contingent based as well.
Okay, I have a $2 million estate consisting of a house, 2 children, and an investment account. Husband and wife. What would be the charge?
That would be a flat fee of $4,500.
$4,500. And that includes what?
That includes multiple documents. So there's healthcare directives for each person, powers of attorney for each person, HIPAA authorizations and releases, a trust, 2 pour-over wills, funding instructions, multiple funding letters, as well as other ancillary documents like a certification of trust, things like that, and also a deed to transfer any real estate that they have into the trust, and we cover the recording costs on that. So that's built into the flat fee.
And then do you charge for an initial consultation?
No.
No. So if someone could give you a call and say, hey, I need this done, you would give them a price or an approximate cost, and that initial inquiry is at no charge.
Yep. Yeah, we do
Okay.
a free consultation, give everyone a quote. If they don't like it, they don't have to retain us.
Okay. And what is your hourly rate?
$550 an hour.
And when does an hourly rate kick in?
That is mainly for administration and litigation matters. So it depends, because now we have other attorneys at the office that charge at a lower rate that handle the general administrative tasks, things like that. And so not everything is usually billed at my rate, and that's why my rate is a bit higher, is because I got a lot of other things to do, mainly with litigation and administrative issues. So.
Okay. If anyone has a question regarding Steve's fees, make sure you put it in the Q&A, and we'll go from there. Let's get into the presentation, Steve.
Sure. All right, did I do that right?
Yes, you did.
Perfect. Okay.
I'm assuming that was your office.
Yep, that's our new building. They're on Irvine Boulevard. We just moved there a couple months ago.
That's the
lots
highest
of work.
door I think I have ever seen. Maybe it doesn't go all the way to the top. Bye.
Okay, today's topic is wills and trust. Go ahead.
So
Steve.
So the agenda is wills and probates, trusts, and estates, and kind of the difference between each of those, the documents and the different types of administrations. So first question is, do you need a will? So if you have only a will and not a trust, you're going to end up having a formal probate administration if your estate exceeds a certain value.
And by the way, what is that like right now in Orange County? Because you're in the Orange County courtroom quite often. What is the situation in the probate court today?
It's extremely backed up. So if you're going into court for a probate action, you're probably looking at a minimum of 2 years. So they aren't even, they used to be setting review hearings to close it out within a year, and I think they're out now closer to 2 years. So.
Yeah. So any kind of probate matter right now, it takes a while to get into court.
Yeah, I mean, you can file it fairly quickly. It's just your initial hearing isn't going to be for about 4 months, and then that's when the administration actually starts.
Okay. So. And so if you don't have a will or have a will, you're going to end up in probate court.
Yep. And without a will, your estate will be distributed to your heirs at law, and that depends on who your heirs at law are, because that could be different for everybody, depending on who has survived you. And if you have a will, you get to choose who the beneficiaries are and dictate how your estate is ultimately distributed. And you can also choose who administers your estate by appointing an executor under your will.
Yeah, and so intestate succession, by the way, a vast majority of people don't have wills. So intestate succession means your children receive it automatically?
Yeah, it's primarily your surviving spouse receives a portion, and then it goes to children as well, depending on whether it's community or separate. There's a split there. And then it goes children, parents, siblings, and it goes up and down depending on how close of relatives you are. So if you don't have anyone that close, you could have many, many heirs at law that your money gets split into.
What's the minimum dollar amount for a probate?
It's right now it's 184,500.
Yeah. And when we say minimum amount, what does that mean?
That means that if your estate is below that, so two different things. The personal property has to be below 184,500. And that means you can use the small estate administration procedures to distribute your estate, which means all that means is that the beneficiaries can collect your assets without having to go through a formal probate.
Right.
But that won't work if you got real estate in California.
Yeah. There's, let's go to the next slide. What is probate?
So probate is just, it's court supervised administration, which means that everything essentially has to be approved by the court with certain exceptions. So if you have full authority to administer the estate, you can send shortened notice periods. But if there's disputes or other unique issues, you may have to still go to court to get approval for taking various different actions.
If you have, if you need a black robe to decide on how you're going to distribute your assets, you're going to be in the probate court.
Yeah, and the difficulty with probate is obviously the timing, because the more complex of an estate you have, the more likely you're going to have to file multiple petitions, which means you're going to only prolong the probate administration process. So in addition to that, probate's a lot more expensive because there's statutory fees that are set for the administrator and also for the attorney for the administrator.
Do you have a slide on that probate rate?
Maybe.
Okay.
Yeah, I sure do. Yeah,
we'll go back
so
to the other, but since we're talking about it, go talk a little bit about this first, because people don't understand how expensive it can be.
Yeah, so probate, the fees are set by statute and they're staggered percentage rates. So the percentage gets smaller as your estate gets larger. And this is up at the top there, you see 4%, 3%, 2%, and 1%. So on the first 100,000, it's 4%. The next 100,000, it's 3%. The next 800,000, it's 2%. And the next 9 million, it's 1%. So 99% of people that are going through a probate are going to be within this range. And it gets shorter, it gets to a smaller percentage as it gets higher. But in this case, if you have $1 million gross estate value, and what that means is if your property is worth $1 million and you have a mortgage of 800,000, the fee is calculated on that $1 million. It's not $200,000 of equity. It's the value of that property, regardless of what the liability on it is. So that's why you see here, if you have $1 million gross estate, you're going to have a $23,000 statutory fee, and that's for the administrator and also for the attorney. So the statutory fees would be $46,000, and that does not include the additional court costs of filing fees and appraisal fees, bond premiums, things like that. And that's aside from the bond premium that varies with each estate, the other fees are about $2,000. So
yeah. Even just publishing, you know, you have to publish in a newspaper 3 different occasions. That can run anywhere from $1,000 to $3,000. So the probate process is expensive. Would anyone want to go through probate? Can you think of a circumstance where maybe a probate is a choice?
Going through formal probate, people usually never want to.
Yeah,
I don't think I've ever had someone that wanted to. Sometimes people try to chance it, because they're right above the small estate threshold, and they expect to spend it down before they die.
Yeah.
But that's, obviously the cost of it and the timing doesn't make it worth it. So,
If somebody just came to you and said, I don't want a living trust, I've heard negative things about a living trust. We haven't gotten into a living trust yet, but they said, just give me a will, a durable power, advanced healthcare. What's the cost for that for a single person?
it varies. It would be somewhere between 1,500 and 2,000.
Okay, let's go back to your other slide. We talked about the statutory fees. What is an administrator?
So administrator is the general term is a personal representative. That's who administers a probate estate. An administrator is someone who is a personal representative when there is either no will or there's a will, but they're not the person nominated as an executor under that will.
So we got some technical terms here.
Yeah, and the executor is strictly the person named in the will to administer the will.
And you don't use a term executor when you're working on behalf of a trust.
Yeah.
Okay. Now, how would the person have title in order to go through probate? In other words, if somebody has assets in a trust, would those trust assets go through probate?
No. So the purpose of a trust is typically designed to help avoid the need for a probate. And if you have something titled in the name of a trustee, then it's not going to be subject to the formal probate administration.
Are you going to go through probate avoiders, joint tenancy? There you go. You're great. Thank you, Steve.
So, yeah, you could have ways to minimize the need for probate is, payable on death or transfer on death designations with accounts.
And by the way,
designations.
Paid on death is so easy to do. Do you recommend people do that for large sums of money, or is it designed for small amounts?
I mean, I wouldn't say it's necessarily designed for either. So you can do it with a very large sum or a small sum. And I always tell people there's risks associated with it, right? The main risk associated with the pay on death, transfer on death, or beneficiary designations is that your beneficiary or the beneficiary of these designations doesn't survive you. And oftentimes married couples will set each other up as the primary beneficiary and then just never think about it. One spouse dies and the survivor just never changes it. Yeah. In that event, it would revert to their estate, and it may trigger the need to go through formal probate.
Yeah. So pay on death is where if you have a bank account, you go into your bank and you fill out a slip of paper that says, hey, upon my death, I want it to go to this person. And when you die, that person goes to the bank, waits 40 days, shows their driver's license, and they get the money. But like Steve said, person has to be alive. Maybe they have to be sane or have some sort of capacity. And there's lots of problems with it. Yeah,
it can definitely complicate situations. And that's why and then the next issue is titling with joint tenancy. That can create a whole bunch of other issues. So joint tenancy.
What does joint tenancy mean?
Yeah, that means that you're holding property jointly with another person and that you're holding it with a right of survivorship. That's unique to joint tenancy. And what that means is that when one of the owners dies, the other owner becomes the sole owner of it. So there's various negative tax consequences to this, but more importantly, it creates conflicts and potential need for court intervention during your lifetime. Because if there's a disagreement about what to do with this property, and they need two owners to sign off on the transaction, and one of them can't or won't, then it's going to require court intervention to resolve the issue. You also, if you have joint tenancy with one of your children, you also lose the full step up in basis upon the death, because it's not treated the same way tax-wise.
So title is really, really important. Last week we went through the durable power of attorney. Does that affect how? Does it have any effect on title?
The power of attorney wouldn't have it would have a limited effect on title. So it wouldn't change the title, but it would give someone else authority to change title.
So legal authority, if somebody has the title in their own name, then they can use the power of attorney to act on the other person's behalf.
Yeah.
And so
that usually will come around or be more relevant when you have a trust that someone didn't properly fund.
yeah. And so most people don't think about a living trust as a methodology to hold title to assets, but that's kind of what it is, isn't it?
Yeah. Mm-hmm.
And what is a living trust?
Go to that slide. So a trust is basically, it's not an entity, because a lot of times people think that it is. What it is it's a legal relationship between property. And during your lifetime, you are both the grantor, the trustee, and beneficiary while you maintain capacity. If you become incapacitated, you're still the grantor, but someone else should become the trustee, assuming that they're aware of the need for that. But you remain the beneficiary. And it's got these three parties are necessary. You'll need assets as well. But it's sort of a legal relationship that obligates the trustee to use the assets for the benefit of the beneficiary.
And so how would title read if you have a revocable trust and you have real property?
It would be the trustee's name as trustee of the name of the trust, and a reference to the trust date.
And so why here in California, in Orange County, why is a trust recommended almost 100% of the time?
So it's usually recommended because most people that own any real estate are going to be subject to formal probate administration. Because if you have real estate in California that exceeds, I believe it's now $60,000, it's going to trigger a formal probate. So basically any property here, unless you're talking about a small vacant lot somewhere in a remote area, usually you're going to have a formal probate if you do not have a trust. So, but you could also do transfer on death deeds, but there's the same risk with that as well.
Yeah. So one benefit is the probate avoidance of a living trust. What about incapacity? Does it have any effect on incapacity?
Yeah. So if you do not have a trust, you would have, say you only have a power of attorney. That power of attorney allows someone to act on your behalf to make financial decisions. And as I explained to a lot of people in consultations, the risk of that is that you don't really know what type of dementia you're potentially going to get. And so if you're planning on protecting yourself from the need of court intervention in the future, if you just have a power of attorney, you could have some sort of dementia that makes you spend money uncontrollably, or just purchase things or change bank accounts to hide it from people you suspect are doing something wrong. A power of attorney doesn't protect you against that because you still have access to your own money. The only way to stop that in that situation would be to appoint a conservator. But if you have assets in a trust, the answer is to get the next trustee involved, because you lose title if you're in that circumstance to the trust accounts, because you would no longer be the trustee.
And how would, upon incapacity, how would that management or successor trustee step in?
Typically the trust will have a provision that provides what it means to be incapacitated, and the trustee would have to follow those procedures to deem you incapacitated. So it doesn't necessarily mean that whoever you name as trustee is going to come aboard and take control of your assets and you lose all control. Typically you'll have a provision in there that allows you to regain control if you are temporarily incapacitated, or if you have a trustee that is doing something improperly.
So
But-
normally the language would be upon a written letter from a physician showing that you lack capacity, the successor trustee will step in.
Yeah.
Or the trustee could say, hey, I'm 95 years old. I don't want to pay my own bills or manage my own money anymore. I'm just going to resign and let the successor trustee step in.
Yeah.
So you could literally create that language, whatever suits your situation.
Mm-hmm. Yeah, or what if it's the problem is a lot of this is planning, right? So you don't necessarily know what's going to happen. It's just, what do you feel most comfortable with right now? Because you may not know what the future entails for you, you know?
So you want to keep it as flexible as possible and still make sure that it generally is the contract does what you wish it to do.
Yep.
Okay. Now, during your lifetime, do you have to change social security numbers? What do you have to do differently if you're well and you have no problems?
Not a whole lot changes for people operationally in their lifetime with a trust. The main thing you have to do is change title to your assets and effectively treat it like it's a formal arrangement. You know, what you don't want to do is switch back and forth to putting things into the trust and not, because it's going to affect the estate planning documents you initially set up.
Well,
But
one of the things that I hear a lot of is that people get a living trust, they get the estate plan in order, and then they don't fund the trust. Fund, F-U-N-D. What does that mean?
yeah, that means to transfer assets to yourself as trustee of the trust. And for real estate, it's important to actually record what's called a trust transfer deed, which transfers it from you, however you were holding title, to yourself as trustee of the trust. And for other items and things that don't necessarily have a formal title, you can execute an assignment of those assets and transfer it into the trust by assignment.
What does that mean? Is that another extensive document of 10 pages long, or
Nope.
what does an assignment mean?
An assignment is just a legal document that effectuates your intent to transfer items into yourself as trustee. It's a single page, 1 to 2 pages sometimes. It's not very long, but if you go to certain places that just, you know, hammer through estate plans, a lot of times they don't help you with the funding at all. Yeah. And so that's an important issue. And it's, as you say, it's an issue that pops up a lot because you set up a trust and think, oh, great, it's done. Not realizing that you've got these other steps that you need to take to actually effectuate those documents you've executed.
And personal property is a lot of times a huge issue in estates. And who is in charge if you don't do an assignment of your personal property to the trust? Who's in charge of your personal property?
Well, it would potentially go into a probate, but there are usually the personal property is not worth a ton, so it can be collected by the trustee under the small estate administration. But it's an issue that creates a lot of litigation and disputes between beneficiaries because sometimes there's very sentimental items, and with a trust you can designate who gets what or a formal procedure on how to handle personal property.
Yeah, or at least what I find is allow the trustee to be the final arbitrator if the family can't work it out themselves, else you might end up in court having a judge decide.
I want to take us back a little bit. There have been a few questions that have come up on this transfer of death item. So if I have my home, for the sake of discussion, I don't have a trust, let's say. I put a transfer on death on my home to so-and-so, who's alive, who's competent, who's very capable of receiving it. Does that avoid probate? Do I have to do anything with court when it was real estate?
Yeah, if you have a transfer on death deed, assuming that it all goes well and it's effective, then yeah, it would avoid the need for a probate.
And I don't need any court thing or any other hearing or anything else to do anything with it. It will transfer.
Mm-hmm.
Okay.
Yeah.
Yeah, there's
And that's it.
so
But it's
just to,
one,
just
no
to-
flexibility.
Right.
What happens on if the individual lacks capacity?
Right.
What happens under fraud, because it's so simple? And by the way, in some families, the money becomes more important than the relationship.
Right. Okay.
So be careful.
And I do want to just clarify on that too. So it's not, none of this is ever automatic, right? There's always some sort of an administrative step after someone dies to effectuate a transfer of the asset.
Right.
So in the case of a transfer on death deed, it's simply a deed reflecting, which includes a copy of the death certificate, reflecting the death of the owner. One important thing about that, though, to keep in mind is, depending on your state law, which they're now enforcing much more strictly, you may not be able to get the person's death certificate. So that's been an issue we've run into in the last year on several cases, is that you just can't get someone's death certificate without a court order. And so it may be more expensive for that person to inherit that property if you have simply a transfer on death deed. In California, it's children, spouses, and very close family members that can get a death certificate. So if it's a friend or some other more distant relative, they may have a hassle obtaining your death certificate in the first place.
We've had that with stepchildren along these, as we've done these sessions, we've had that with stepchildren.
Is there any other questions, Don?
No, we're good.
Okay, let's go to the next slide.
I think we did that.
Yeah, this is a really important slide.
Okay. So the importance of having an estate plan generally is mainly to provide for you during your lifetime, and to ensure that if you become incapacitated, there's some sort of a plan set up to, one, provide for your care, but also to ensure that your financial matters are taken care of. So on the left side, we have the incapacity documents that help with that. And there's the financial power of attorney, which allows you to appoint a person to make financial decisions for you personally. And then the advanced healthcare directive, which is a combination of a living will and a healthcare power of attorney. That's just what we call it here in California. And advanced healthcare directive will allow you to appoint someone to make medical decisions for you and to determine what happens with your remains after death. And the HIPAA authorization and release allows your agents to obtain, assuming it's drafted correctly, allows them to obtain confidential medical information, which assists them in making the decisions they need to make under those documents. On the right side, there's the pour over will, and that only becomes effective upon your death. Upon your death, the powers of attorney will terminate, with the exception of the advanced healthcare directive that will extend for some time afterwards, depending on how exactly it's drafted. In between both of these categories is the revocable living trust, because it's effective as soon as you execute it, assuming that you've transferred property into it. It will assist you in the event you become incapacitated, because it sets up a line of succession for trustees to come aboard and make financial decisions for you in regard to the trust asset. They will not have control over things that are not in the trust. That's where the financial power of attorney comes into play. And then upon your death, the reason that a trust survives is because it's a contractual relationship. It's not an entity and it's not a person. It passes simply to the next trustee, and the trustee simply follows whatever the terms of the trust set for.
Excellent.
All right. So you've got different types of trust. You can have a revocable trust and an irrevocable trust. And a lot of times it's a misnomer because it's a little bit confusing, right? If you set up the standard trust that most people set up to assist in avoiding the need for a probate, it's a revocable trust, but it's only revocable during your lifetime. If you become incapacitated, it may potentially become irrevocable, but it actually will transition into an irrevocable trust upon your death. That's what they're designed to do. Irrevocable trusts, the way that they're commonly referenced, is they're irrevocable from the start. So they cannot be changed, typically cannot be amended, but they can be. It is possible to do that. And all these other different issues here that you see, a trust is really whatever you make it. So you can set up all sorts of terms. What I always tell people is, if you're going to make, the more complex you make your trust, the more expensive the administration is going to be, because you have to think that neither you or I may be here in the administration. We may both be dead. And if that's the case, someone else is going to have to figure out what it was we meant by whatever we wrote down in this trust. And sometimes, as Pete knows, we have to go to court for instructions, because, you know, some of these trusts last 30 years, 40 years. We don't know what was intended back then because the law was completely different.
Yeah.
So some of those things can really have an impact. So that's just something to keep in mind when you're setting up a trust or any estate plan. Yeah.
Well, you need to know, as the legal counsel for the person that has hired you, the whole family history. Is it a first marriage? Is it a second marriage? Are there any problems within the family having to do with children? Is anyone mentally ill? Does anyone is on government benefits? Has anyone declared bankruptcy or has had litigation problems? Is anyone a spendthrift in the family that needs additional support? It used to be setting up a trust was about taxes. Is the living trust today, just a simple living trust, have anything to do with taxes today?
Somewhat. I mean, it does if you have a large estate, but for the vast majority of people, it isn't going to make a big difference. And even when the current estate tax law sunsets, it's still not going to affect the vast majority of people.
Yeah. And how often do you see an irrevocable trust being used?
Typically, it has something to do with tax issues for someone that does have a large estate.
Yeah. So let's go to the next slide.
I think we talked about the benefits and drawbacks of the revocable trust here.
Go through that. How does it minimize the risk of a conservatorship?
So it minimizes the risk of a conservatorship, because if you become incapacitated, it should be designed at least to pass on the trusteeship to another person. Even if it doesn't specifically say that, there are ways to pass it on to the next trustee. And because of recent changes in conservatorship law, the courts are actually leaning a bit more toward no conservatorship. If you do have a trust set up, they will usually not grant a conservatorship in favor of hopefully assisting the person through the revocable trust. So yeah, that's
from my point of view, that's one of just the major benefit is to avoid the conservatorships. Drawbacks, you know, we have very few people talk about the drawbacks of a living trust.
Yeah. One of the drawbacks is the cost. A lot of people don't want to incur the cost. And, you know, the difficulty with being an attorney that does drafting and planning is it's hard to explain the cost savings to people, right? And that's why I explain what the cost of a probate is and these issues with conservatorships, because they can cost you tens of thousands of dollars, if not hundreds of thousands. There's also no oversight to the trust, right? Trusts are designed to be private. That doesn't mean that they won't end up in court, but the drawback to that is that if it's set up in a certain way and you've put in a trustee that you thought you could trust but ultimately you couldn't trust them, and they take control of your assets, you may not be in a position to take them to court and enforce your rights. And that could be difficult.
What are the rights of a beneficiary in a trust if they have a renegade trustee?
They can seek the trustee's removal. It depends on the trust, right? So you can go to court. Court ultimately is the answer when all else fails. But typically you want a trust that's designed to give you authority and flexibility during your lifetime to modify it. So if you're the trustor and you become somewhat incapacitated, but you're still aware of what's going on, and you see a trustee doing something wrong, usually your trust will give you the ability to remove that trustee and replace them with someone else, or simply to just amend the trust and take that person out as the trustee.
So you said on the drawback, trust administration at death, you save 50 to 90% as compared to a probate. Usually people name family members as their successor trustee, son, daughter, whatever. Do most of the family members charge for their services as a trustee, or can they, or should they? Talk a little bit, because I'm sure that family members talk to you about this.
Yeah, it really varies, honestly. It depends on multiple things, but primarily it's how successful is that trustee, right? Are they going to feel like they're getting some sort of a bonus more than the other siblings who may need the money more? That's a big factor. Another factor is a lot of people don't necessarily want to take compensation, but they may decide to take compensation later because of disputes and litigation. And that, unfortunately, that only leads to more disputes and litigation, because unless you were going towards taking compensation the entire time, you usually haven't kept track of time, things like that. But yeah, many people feel a familial obligation to just do it for free. But when they realize how much work is actually involved, they usually want to get paid, because there is, as you know, Pete, there's a lot of work involved in administration.
Yeah, one of the issues too is, hey, mom, dad did a living trust and we don't have to go through probate. And I heard probate costs expensive, it takes a lot of time, and a living trust, hey, where's our money? And mom, dad died 3 months ago, and how come I don't have a distribution yet? What is the typical length of time from the day to death to finally a beneficiary receiving their monies?
It depends. It's a minimum of 6 months. So that's why I mentioned earlier, none of this happens automatically. No matter what you do, there's an administration process. And just to elaborate on that a little more, the process isn't designed to get the money to the beneficiaries. The process is designed to make sure that your creditors and things are paid first, and that your affairs are settled.
Taxes are paid.
A deceased person. Yeah. And then whatever's left over, that will go to the beneficiaries. But the reason that all these processes exist is for the benefit of creditors and things, to ensure that people don't just die and try to escape paying liability.
Yeah.
So
common fallacies. I love that. If I put my assets in a trust, can a creditor get to it?
Yes. Yeah. There's certain types of asset protection trusts, which are, going back to the other slide, those are the irrevocable trusts. And the reason that they provide asset protection is because you're actually transferring the assets to a third party, at least in some portion, and you're making an irrevocable transfer. But if it's just a regular revocable trust, it's not providing asset protection, and oftentimes people think that it will.
Are you going to talk about the 120-day notice issue?
Probably in a few slides.
All righty.
Do you want me to jump ahead to that?
No, go right ahead. Okay. Go to the next slide.
Okay. So funding the trust, I think we kind of covered that already. Is there anything you want to add into this, Pete?
No, you're doing a great job.
Okay. Same thing. This one is just a little bit different. If you have stock cooperatives, if you know anyone, or if any of the viewers are in Leisure World or Laguna Woods, they have a lot of stock cooperatives, and those are actually different than condos and real property, because you have a stock certificate, and the way that is transferred is different. So if you're thinking about moving to one of those areas where there's a co-op, if you're going to finance the purchase, you want to make sure you set up a trust before you make the purchase, because you may not be able to transfer it into your trust if you have a mortgage on the property. So just always want to throw that out, because that's a common thing that most people don't realize because they don't tell you. But yeah.
Talk a little bit about the out-of-state real estate.
So out of state real estate, if you have anything in another state, that's you're going to need a deed in that state transferring into your trust. And there's no typically no rule against that, but you will need to, you don't necessarily need to get an attorney, but you may need to get some real estate agent or title company to assist in the transfer. And there are also some websites, if you want to try to do it on your own, that will allow you to input information and they'll prepare a deed for you. So
why is it so important for a single person who's not married to have a living trust?
Because I guess all of the reasons we've kind of talked about, right?
Yeah.
But if you don't have a trust set up, it all kind of plays together, right? If you become incapacitated,
Well,
no one
usually
may know what to do.
a single person has the title in their own name.
Yeah.
So what happens if you have property titled in your own name, not in a married couple or in a partner, in your own name, and you suffer from some sort of incapacity? What happens?
Well, you cannot sell it. You won't be able to do a whole lot unless you have an agent under a power of attorney that you've appointed, because you won't be able to go through the process of selling it if needed. But two, even if you were to get a reverse mortgage, they have fairly strict procedures. If they believe you're incapacitated, they're going to require the agent to fill out the paperwork, or they're going to force you to have a conservator appointed to fill out the paperwork.
Yeah, basically it's a conservatorship. That's probably your only answer to make it through until you're deaf. And that's what you want to avoid. It's not a black and white thing. So for single people, please have a living trust. If you have property out of state, have a living trust. You don't want to go through ancillary probates. Let's go to the next slide.
Yep. This one is just a slide discussing how to retitle different assets. I'm sure we've covered this already.
Go back for a second. You could name co-trustees. Talk a little bit about co-trustees.
Sure. So with a trust, if you're a married couple, when you set up a revocable trust, you will actually both be co-trustees initially. And the way it works, typically, because there are some people that do not want to be the sole trustee after their spouse passes away. You could set it up to be some other person, but typically you're both co-trustees. And then when one of you is unable to do it, the survivor or the one retaining capacity will be the sole trustee.
Should you name your children as co-trustees? I can't decide which one, what one to keep an eye on the others. So I'm going to name the two or all three of them as co-trustees.
You certainly can do that, but there's a lot of risks with it, because having co-trustees is the equivalent of having a jointly held property, right? So the trustees will hold title to the property. And the only way to transfer title to things is for both of them to agree. Otherwise, they will end up in court. And in the context of trust administration, if you have co-trustees, even title, if you have disputes about how the trust should be administered, how things should be distributed, you're going to very likely end up in court. And one of the big things is, if you put siblings in there, if they have any conflict, then they're probably going to end up in court, because once the common connection between them is gone, things change. And if you're thinking about doing that, my best suggestion is to go to each child separately and discuss it with them, see what their thoughts are, because they may have thoughts about how their sibling is going to react once you're no longer there that you may have no idea about.
Very well said. Yes, Don.
So at the other end of this process, if you will, let's discuss a burial plot. So if I have a burial plot and I have prearranged for my cremation and burial and all of those other nice things, do I put that into the trust? Is there any issue in putting it in? I mean, I'm going to be dead and use it, so it's not like my beneficiaries aren't going to get it. I am, because I'm going to use it. But
yeah, you wouldn't put the burial plot into the trust,
because it's really in your advanced healthcare directive, because that's what says how to handle burial.
Yeah.
Yes?
Yeah. Interestingly, though, just so everyone is aware, there is a secondary market for burial plots. If you're ever curious, there are actual brokers out there. I had to deal with it on a case one time. But yeah, you wouldn't put it in there. they also have very particular rules for it as well. So
Okay.
that's a unique issue.
And yes, and another question that has come up, and I think some people have touched on it before. If I have a revocable living trust, I do not get a separate tax ID for it.
Yeah,
I use my tax ID.
Yeah, you'd use your social security number to report taxes on it.
Which is why the trust pays no taxes, have any other reporting or anything else as long as you're alive. There isn't anything because it all passes directly to you, the person who set it up.
Your social security number dies with you. So you have a separate tax ID number once you're deceased for the trust.
If the property was in community property with my spouse and I have the trust, what does it transfer to hers?
Yes, to her social security number.
And then continues on and simply being there may be some irrevocable items in there, but otherwise it just passes on.
Yeah.
You don't retitle or do anything else because it's already in the trust.
Correct. So tax ID numbers are important because you have a tax ID number for your probate estate. Those things that you didn't fund
Right.
are titled in the trust, and you have a tax ID number for your trust estate. So sometimes upon death, we'll have multiple tax returns under different tax ID numbers.
Mm-hmm.
Boy, that clarified it. Thank you.
Let's see. So a lot of times I get a question also on checking accounts. Should I put my checking account in a trust? Talk a little bit about that.
Yeah, you should. There's different. So yes, I mean, generally speaking, everything should just be transferred into the trust with the exception of retirement accounts and things like that.
Yeah.
But for certain things, so this is an issue that's come up a lot because as people are getting older, the issue becomes, I'm unable to pay the bills, but I don't want to lose control of my assets. And so a solution which doesn't require doing a new power of attorney is you can actually set up a special power of attorney for a bank account through a bank and set up a checking account in your personal name. That allows a child or whoever you want to be the agent under the power of attorney. It allows them to help you with bill pay, and you can still monitor it. And you can control how much money from the trust you transfer into that checking account. And you want to keep a low balance because you don't want it to get too high to trigger a probate. But that's a good way, sort of a happy medium of people getting assistance, but also maintaining control of their assets.
Yeah. But if you don't, I always recommend individuals put their checking account into trust. Make sure that you take your trust document to your financial institutions. So whether it's a bank, a brokerage firm, the last thing you want to do is to die and you don't have these institutions or your account titled in the name of the trust. Because what happens then? What happens if we just had this situation just come up on another case with you, in the sense that they had their Laguna Woods condo titled in the trust, but all the rest of their assets were in the individual's name. What happens under those circumstances?
Usually it triggers a probate. So, the difficulty is there's other summary procedures that are possible. Like one of them you'll hear is like a Hegstad petition or probate code 850 petition. The problem with those is they may work, but they may not, because if the trustee is unable to get your personal financial records reflecting that you owned this at the time you executed your estate planning documents when you tried to transfer things into the trust, it may not be successful because there's no chain for the court to follow that you owned this at the time and that you intended to transfer it into the trust. What
is a pour over will?
A pour over will is just a will, but it's a will unique to trusts that essentially all of what the will does is it distributes all of your assets from your estate into the trust.
So, and then the trust distributes the asset to your heirs. The will does it. The will distributes to the trust to the heirs. Is that correct?
Yeah, to whoever the beneficiaries are,
Okay.
not necessarily your heirs. But
Okay. Thank you for that correction. How do you eliminate people who from your can you eliminate children from your as an heir to receive your property?
yeah, you can disinherit people. No contest clauses are they're effective. They aren't a foolproof plan, right? So what that means is you can't prevent someone from contesting your trust. But what you can do is have a no contest clause, which acts as a deterrent to people to say that if they do contest it, they won't get anything. The problem is that they're already cut out and not getting anything. They have nothing to lose. So something to think about with no contest clauses. Some people are comfortable with it. Oftentimes no contest clauses, in my experience, it's usually sporadic and random issues that pop up with amendments and people that probably shouldn't have been getting gifts in the first place. If you have an estranged child, generally they don't contest it unless there's a large sum of money, because if you're estranged, you sort of assume you're going to be written out and you've come to terms with it. So yeah.
Families, got to deal with the families. Next slide, Steve.
So business interests, these are a bit more complicated, and I won't go into too much detail with it. You can assign certain interests into your trust, but there's also formal documents and things with each type of business that you want to properly change title to make sure it's in the trust. But if you have business succession planning, there's a whole different issue there to deal with, and it's probably outside the scope of what we're going over today.
Yes. Let's go to the next safety deposit boxes.
I just had a case yesterday. We spent 6 months trying to get access to this safe deposit box.
Yeah.
And got access to it yesterday and it was empty.
Yeah. Please do not put your estate planning documents in the safety deposit boxes. Do not put certificates of title in your safety deposit boxes. It's not like it used to be. And if you do have a safety deposit box, do exactly what Steve there recommended. Retitle.
Yeah.
Promissory notes.
Yeah.
Do people have problems with promissory notes, especially when you lend money to your children?
Yeah. The big problem is that they don't have one. And so that's the difficulty, right? If you're lending money to your children, because it's actually fairly common that people do that. So, just to a lot of the viewers out there, it seems like, oh, my child needs help and I'm loaning them money. You're not alone. It's actually extremely common for parents to help their children out with money, loaning them money, gifting them money. But it does create a lot of problems. And it creates a lot of litigation issues and distribution issues in the administration, because no one knows whether you intended this to be a gift later on, or if it's a loan to be repaid. And maybe you leave some documents showing, oh, I wrote him a check for $50,000 a year before I died, right? And there's no reporting or anything that was a gift. And so the new trustee is the other child, right? Because they were put in as trustee because they may not have necessarily needed any help. And now they want that sibling's share to be reduced by $50,000 because they're treating it as a loan.
Yeah.
And anytime you do stuff like that, you want to make sure it's documented. You can even effectuate it by an amendment to your trust, or simply writing some sort of a letter to both children, leaving it with your attorney. Things like that will help out.
Yeah. Paper saving bonds.
Yeah, those, if you can, liquidate them, because that can be very difficult, especially if you have the physical bonds. That can be extremely difficult, and sometimes it just costs a lot of money. Did we have a question pop up?
Yeah, have a reason to have your bonds or stocks in paper form. Open up a discount brokerage house and put it in there. It's so much safer and it's easier to deal with. Don, you have a question?
Okay, so this could be a tiered question as we go through this. Grandpa left the house to his grandkids. One's over 18, one's 18, and the other's 12.
Mhm.
We're giving something to a minor, a house to a minor. Don't we need to set up a trust to maintain that?
Well, when can you have title to property, Steve?
Well, you can have title to property as a minor. You just won't be able to do anything with it.
Shouldn't be able
And
to.
it's
Yeah,
likely
okay.
it's likely going to trigger a guardianship. You're gonna need a guardianship. So if you
Yes, I agree. So then the next part of that becomes the mortgage is greater than the amount in the bank accounts. So one trustee wants to sell the house, the other doesn't. What should be done? My guess is we're going to probate.
Let me just kind of try to clarify what this question is. So you're saying that there's a property that's going to one adult and one minor, and it has a mortgage on it. Is that the
Yes, correct.
Okay. So, well, yeah. Anytime you have minor beneficiaries, you're going to run into problems. So hopefully no one has children super late in life, and that doesn't become
Well, this is a grandpa gave it to the grandkid.
Oh, he did.
Yeah. I'm not that old and I have those.
Yeah, I mean, that's just, it's poor planning is what it is. Essentially doing it that way, you're going to create a lot more costs for everybody, because oftentimes they'll have a provision in the trust that allows it to be held in trust for the minor. If there is a trust. If there's no trust and it's a probate, there are some exceptions and some ways to avoid a full-fledged guardianship, but it's rare and it's just costly, because when you have a minor and you're going through the court system, the court has to appoint what's called a guardian ad litem for that minor, and that person is usually an attorney that gets paid out of the minor's estate or some other source. And all it does is create unnecessary court involvement and just a much greater expense.
And apparently the latter next part of that one becomes their trustees who don't agree with each other on what should be done, sell the house or not. So now we have conflicting trustees.
Yeah. Well, and that's the risk of putting children in there, right? If you have a gift to one of their children, your grandchild, then they may want that house saved for their child, but the others don't want that. And then, it's going to end up in court is the short answer.
Yeah.
So.
And just there's one other question. I just want to make sure we have a clarification of it. Why is a pour over will versus a trust? My understanding is I have a trust and most of my assets are in that. I have a few things outside of it, maybe a car or something else. The pour over will puts it into the trust. So therefore I've avoided probate. Now that isn't for retirement accounts. Those are separate. Other things are separate. But that simply puts the rest of what may not have been put into the bucket, but you don't want that to be a really large amount.
Yeah, I always explain it as the ultimate fallback. If everything else you did to try to get your assets into the trust fails, your will acts as the conduit to get it into the trust, whether that's through formal probate or small estate administration.
Okay.
And talk a little bit about a car, because we're going to, with that kind of question, brought up a car issue as well, and we have it on the slide.
Yeah,
okay. Thank you.
The way vehicles are transferred is very different. They have unique law that applies to them going through the DMV, and that also varies by state.
Yeah.
So
and
usually you don't need to transfer that into the trust.
Yeah, and AAA is wonderful to get the transfer done. It's much easier than the DMV, but it handles completely separate outside of a will and a trust. Vessels the same way. Boats. Steve, the same thing.
To an extent, depending on the type of boat. But yeah, it all has to do with title through a government agency.
Same thing with mobile homes.
Yep, I was about to say that. Same thing with mobile homes. Those are actually unique. So if you have a mobile home, make sure you tell whoever your estate planning attorney is. There are specific forms and things to fill out with the Department of Housing and Community Development. And there's, the website's on there. You can go look it up. They have probably 1,000 forms on there. But yeah, there's those get complicated, but for purposes of trust and things, it's fairly easy to change the title, and you can actually put beneficiaries on there, but there's a specific procedure for that as well.
And we talked a little bit about tangible personal property, but what is a personal property memorandum?
So if the trust allows for it, you'll usually have a provision that says that I can leave a letter or a note or some other written direction to my trustee to distribute specific items of personal property to specific people. This comes up a lot with like artwork or jewelry, things of a personal nature that some family member specifically may want. So it varies by the person, but what it allows you to do is not have to go back to an attorney every time you want to change the gift of some piece of personal property.
Yeah, and we've got approximately 20 pages to go, and we have about 10 minutes left, Steve. So let's go through some of the slides and get to the end.
You tell me which one's to skip.
Power attorney, small estate, we talked about. Hegstad, port over will, we talked about. Let's go to the next slide. This is really important, and all the information that the attorney needs to have an estate plan. If you had to pick out one or two items, where do most people lack in having this information for you?
So the trustees, people usually don't have that together, and because what happens is I explain the risks of having a child or whoever they may be wanting to put in, and they start second guessing it. And then the other issue is the beneficiaries.
Yeah.
So
so two things that really are important in a trust that aren't boilerplate, that takes some unique planning, is who's going to be your successor trustees, how do you want them to succeed, under what circumstances, etc., and also how you're going to distribute your estate. Are you going to give a portion to 35 and the rest at 50? How you're going to structure that distribution is really important to think about and then discuss with the attorney, because you've seen pretty much every kind of distribution out there.
Yeah. Yep. And and I always tell people the distribution scheme you have is sort of whatever your imagination can come up with. Just keep in mind the cost of administrating and carrying out that plan.
And most of your litigation comes out if there's an unequal distribution, I'm assuming.
Yeah, not necessarily unequal, but just when you have trusts that go on for years or designed to go on for years, because at a certain point, if you're giving a gift to a child and someone else is controlling it, it's no longer a gift for mom and dad. It's mom and dad left me this money and this guy's holding on to it and won't give it to me.
Yeah.
And that's how it's seen.
And we're living longer, and people are dying who we have named as our beneficiaries in our trust. So you have to think about, hey, what if my child is no longer alive? Do I give it to the grandchildren? Do I give it to a charity, et cetera, et cetera? So remote contingent beneficiaries is really important. Let's go to the next slide. And gift tax. We haven't talked too much about that, but spend a couple of minutes on a gift tax. What is it?
Sure. So the federal gift and estate tax exclusion right now, essentially there's no estate tax unless you exceed this dollar amount. And I think it's a little bit higher in 2023, but it's going to revert back down in 2026 unless they extend it. So, without getting into
as a note, we did cover this extensively in the first week.
Okay, let's go to the next slide.
Capital gains. Was this first week?
We're talking basically. You're
Same
looking
thing.
at the step up in basis. So we discussed that as well. And marital subtrust. Some people who have estate plans 10 years or older have AB trust. What's your recommendation for them today?
You don't necessarily need it. A lot. So if it was done a long time ago, 10 plus years ago, you probably had a trust set up to account for the estate tax laws in effect at that time. And it's all changed since then. Actually, I guess it'd be 15 plus years ago now. But basically you may not have a need for it. And if you don't change it, what you may be doing is actually tying your surviving spouse's hands and making them account to your children in the future.
Yeah.
So could cause more litigation.
A lot less need for an AB trust today. If there is, please see the attorney. Maybe there's a need for because of a second marriage, but then an AC trust might be more beneficial because of the fact that you get to step up in basis. Let's go to the next slide. And what
Sort of.
Let's see, what's the point here?
This is just sort of explaining what the difference, what an example of a split could be after the first death.
Okay.
So the surviving spouse can still control half of the property, while the deceased spouse's share becomes irrevocable. And this is where I was saying it may lead to litigation, because if you have different beneficiaries under the irrevocable portion, they might be able to bring the surviving spouse into court to enforce their rights if they think something is going wrong, or the surviving spouse is not following the terms of the trust.
If you have a second or third marriage and there's children from a previous marriage, please see a competent estate planning attorney, because a lot of times those end up in litigation. Let's go to the next slide. We're talking about here the AB trust, correct?
Yeah.
Yeah. So let's go to the next slide.
This is all
the AB trust. Talk a little bit about, let's see, portability and the estate tax exemption today.
So now there's an unlimited marital exemption, so you can transfer all to your surviving spouse without any
no taxes between spouses.
Yeah.
And you want to maintain that $12 million. And that's what portability means, from one spouse to the next.
Yeah.
And
there's optional. These slides kind of go into the different variations and some examples of the AB split.
Subtrust. What are they?
Yeah. So this is a subtrust is a trust that's created within a trust. And so in this context, what this slide is explaining is the subtrust that get created for these marital pet trusts. One is irrevocable, while one is fully revocable and amendable by the survivor. The irrevocable ones, yeah.
You use subtrust for heirs that may have a special need, a spendthrift, a drug, some specific thing that where they can't handle all the money all at once.
Yeah. Yeah, and here this slide kind of is an explanation of the different types of distribution schemes that you could have, lifetime trusts like that, where Pete was referring to, where you may have someone that needs someone else to control their finances, and you may want to have whatever you're distributing to this person, you maybe want it to last as long as possible. And depending on the size of the estate, something just to keep in mind with that is a lot of people want to do it, but they'll set up a trust of $50,000, and one, no one's going to administer that because there's not enough money there because it's too expensive. But two, if you're trying to set up an estate plan like a very wealthy person, the difficulty is that the reason a wealthy person is able to do that is that they have enough assets to support the ongoing costs of such an administration. So if you underfund a trust, it can essentially undo your intended benefit to the person.
Yeah. To explain the difference between a specific gift and the residual gift.
A specific gift is a gift of specific property, whereas a residual gift is usually a percentage or some sort of a fractional interest of whatever is left over.
And a specific gift, let's say I leave $100,000 to my son, and the residue I have split between my 3 children. how soon does the one son receive that 100,000?
Typically, they would receive it first, and within 1 year of death. Otherwise, it begins accruing interest unless the trust says that it doesn't accrue interest. So,
Okay. So do you recommend specific gifts, or do you recommend percentage residual gifts?
I don't make a recommendation as to what someone should distribute. I kind of give people options. I will make recommendations based on what people tell me, but it really varies with everyone, because it depends on what your goal really is.
Next slide.
Sometimes you got it.
Thank you. Timing's running out.
Okay, no, that's
Thank
good.
you.
No,
Yeah,
we
just
got
tell me.
special needs, we got pet trust. We talked a little bit about that. Let's go to the next slide. And there is all sorts of types of trust depending on your situation. So we're going to go into the charitable stuff in the charitable section and irrevocable trust. And we're talking about the subtrust that we just did previously. Intentional defective trust is an income tax strategy, and that gets into your more wealthy situations that you should talk personally with your attorney about. Next slide. And limited partnerships, transfer LLCs. Again, if somebody has a lot of LLCs, you can put them in a living trust. Please talk to a competent estate planning attorney. And insurance, domestic asset protection trust, offshore asset protection trust. Those are all high-end, wealthy individuals that may want to consider these kinds of things. And thank you, Steve.
Let's back up. Let's back up to one that I made you run through really quickly, and I apologize. Pet trusts. What do you mean I can have a pet trust? How can I have a trust to a pet?
So you can set up a pet trust. I generally don't recommend it, only because we usually outlive our pets. It is possible that your pet will outlive you, but oftentimes setting it up is not worth the amount that it would cost to administer it.
But I dearly love my pet. I dearly love my pet, and because I don't have children, my pets are my children. Therefore, if I set up, for instance, possibly with something like Bluebell in Laguna Canyon for my cat, promoting nonprofits, that would certainly be an alternative. But you can set up a trust to take care of the animals after your death if that's very important to you. So yes, those are legal and allowed.
They are.
Okay.
Or you could just say, hey, I'm going to give $10,000 to X person to take care of my cat.
Yeah, you could do that, or you could set it up. Some of these companies, I think Bluebell might as well. Some of those charities will allow you to set it up before death, that they're going to take over your animal, and you can actually leave a gift to that charity.
Yeah, you got it. Okay.
And Bluebell, in fact, is one of the sponsors, and I believe in a couple of weeks will be here with us in 2 weeks, I believe. So just absolutely, and they will talk about it. Be happy to. So anyway, okay. We are. We've now covered all the questions that we had, and so Steve, if you want to stop sharing, there you go. Thank you. We're at 10:30, and a moment or two after. This has been It's Your Estate. And we did wills and trusts, and we all thank you very much. And I know that Pete's going to want to do a raise the hand in a minute. So what we're going to do is, Steve, thank you very much. Pete, do you want to make any thank you notes?
No, we went through a lot of material. Steve, if somebody has a personal question, can they email you? Is that the best way, or can they give you a call to get you to answer that question?
Yeah, the best way is just to give us a call at the office.
Okay.
If you email me, the difficulty is there's conflict issues and procedures we have to go through as a law firm.
Okay.
So.
Okay. So best thing is to call. By the way, we're going to, in just a minute, allow anyone who's online now to ask any further questions.
Before we do that, we're going to turn off the video so that we do not, because that doesn't need to be included in here. And so therefore.